All right, welcome everyone. We are going to go ahead and get started. I want to be mindful of your lunch hour or whatever hour you are on. In the Mountain Time Zone, we're on our lunch hour. So welcome to another one of Holland & Hart's regular webinars. My name is Melissa Starry. I am an associate in the Healthcare Practice Group, and today we're going to talk about new and old rules for interpreters and translators and auxiliary aides, the provider obligations. And when I say new rules, I am talking about a proposed rule that was fairly recently issued, and we will talk about that a little bit more. Here we go. Here's our important disclaimer. Read that at your leisure. A few preliminaries. This is an overview of relevant laws concerning communication with patients or companions. And I'm mostly going to address federal law, so keep in mind your state laws. Most of the states are going to back the federal requirements. Some states could require additional protections, so keep in mind the state in which you are located. They might have some additional laws that you'll want to take a look at. There are additional laws that apply to other issues sort of in this arena. We're not going to cover those. I'm going to provide, like I said, an update of the new proposed rule, but we're mostly going to talk about communication issues today. Again, look at your state laws, but also the application of the laws is going to depend on the individual facts of your particular situation. So you're going to want to take into account the type of provider, the needs of the patient, the nature and complexity of communication involved, the provider's resources, reasonableness of provider's actions, and the aggressiveness of the relevant government agency. And also keep in mind the law is evolving. The proposed rules that I'm going to talk about are just that. They're proposed. Comments are due fairly, the comment period is almost over. So keep in mind that the laws are evolving. All right, so you should have received a copy of the slides. You should have also received some written materials. The guidance from HHS, I think, is one of the most important of the written materials that we provided for you. Everything that we have here, the slides, the recording of this presentation, those are going to be available on our website. So if you want to go back and listen to it again or share it with someone else, feel free to do so. If you do have any questions, I'm not sure if we're going to have time for questions during this hour, but if you do have questions, go ahead and submit them via the chat function on the WebEx, or you can also just email them to me directly, and I will hopefully have an answer for you. So let's talk about communication barriers. What kind of communication barriers are we talking about? We're talking about communications or barriers with the patient or personal representatives, and some of these issues could be that the patient or their personal representative speaks a foreign language, or they suffer a disability that impairs effective communication, such as if they're hearing impaired or visually impaired. That's what we're going to be talking about today. There are other communication barriers. We are not going to talk about these today, but for patients or personal representatives who lack sufficient education to understand the provider or lack the sufficient capacity to understand the provider, those are additional communication barriers. Why do we care? You probably your initial reaction is, well, because the regulations tell us we need to care. But that's really the least of your worries. You should be caring about this because you cannot provide proper care without effective communication. There are a lot of horror stories out there where a provider provides care without effective communication and something bad happens. So the inability, if you can't effectively communicate, you're unable to obtain the information necessary to provide effective care. And also, how are you going to get informed consent if you can't effectively communicate with the patient or their personal representative? There's also potential for provider liability resulting injuries, malpractice, of course, but then there are individual torts that patients could bring against you: battery, false imprisonment, lack of informed consent. Any other torts that a plaintiff's lawyer could come up with, you could be hit with if you can't effectively communicate with the patient. There's also licensing and ethical standard issues, accreditation standards, and then, of course, the anti-discrimination statutes may require reasonable accommodations. So the government has been, for several years, ramping up to remove barriers to access to health care, and ineffective communication is a barrier to access to health care. In 2012, DOJ launched their initiative where they go after entities for ADA violations, and you can go to their website and see the different actions they've taken against healthcare facilities. A fair amount of these do deal with hearing impaired patients. Why else should we care? In a 2008 case in New Jersey, a physician declined to pay $200 per visit for an interpreter requested by a deaf patient. The physician claimed he couldn't afford the interpreter. Apparently there were also some bad facts here, and the physician was somewhat belligerent to the patient, and the physician, instead of agreeing to pay for the interpreter, communicated with the patient through his family members, and the patient sued, and the jury found violations of the anti-discrimination statutes, and he was held liable for $200,000 in damages and also $200,000 in punitive damages. I think that that's probably owing to the sort of bad facts in this case. So $400,000, which is a lot more expensive than a $200 visit for an interpreter. OCR is also going after entities. They're in charge of enforcement regarding patients with limited English proficiency. So they're looking at complaint investigations for those. You can go to their website and read their enforcement success stories if you'd like to be a little bit frightened. Even if we aren't worried about the government, patients or personal representatives also often understand the law better than providers. They're understandably sensitive to discrimination issues. They are educated about the law, they're educated about their rights, and they're educated about your responsibilities. And so you should also be educated if you're going to be dealing with patients who are educated about their rights and your responsibilities. Be careful, though, because some patients may try to impose obligations beyond those required by applicable laws. For example, demanding their own choice of interpreters or auxiliary aids, or demanding that you pay for an interpreter or auxiliary aid that the patient himself or herself brings. So there may be some misunderstandings, and you want to make sure that you know the law so that you don't have to go further than you are required to by law. And then, in addition, patients and their personal representatives may be willing and able to file complaints against you if you act improperly. So you really do need to keep all of this stuff in mind. The general requirements, this is a general rule. A provider must generally make reasonable accommodations for persons who do not speak English and persons with a disability that impairs effective communication. A provider generally cannot require the patient to supply their own interpreter or auxiliary aid, generally cannot charge the patient for cost of the interpreter or auxiliary aid, and generally cannot refuse to provide care even though cost of the interpreter or auxiliary aid may exceed the cost of care. That's just the law. Like, that's just the law. With all that said, however, I would rather that you decline to provide treatment than try to provide treatment without effective communication. So it would be better to defend a discrimination claim than a malpractice claim if you really cannot provide effective care because of the communication problem. And that being said, it is much better to comply with the law. So that is why you are all here and listening today, hopefully. So let's first talk about foreign language issues and limited English proficiency. The applicable laws, Affordable Care Act, Section 1557, prohibits discrimination on the basis of race, color, national origin, sex, age, and disability under any healthcare program receiving federal financial assistance. On September 3rd, HHS issued new proposed rule on non-discrimination in health programs and activities. And what this new proposed rule does is incorporates the existing anti-discrimination tenets of Title VI, which we'll talk about, the AIDS Discrimination Act and Section 504 as they apply to healthcare. And it also extends the sex discrimination protections of Title IX to healthcare. Title IX for educational programs, they are extending the sex discrimination protections to healthcare. I'll talk about that briefly. And then it also incorporates the longstanding HHS policy guidance on the provision of language assistance services. And that policy guidance is one of the things that we've provided to you. And so the Affordable Care Act, which was enacted in 2010 now, the statute has already been in place, and in fact, OCR has been responding to complaints under that statute without the rules having yet been implemented. So OCR has been and is still responding to Affordable Care Act discrimination complaints. It's not like you're going to get a free pass until these regulations are finalized. So who's subject to the new proposed rule? Health programs and activities that receive federal financial assistance from HHS is what has been proposed. It's also what's been in the statute, so it's probably going to end up in the final rule. Examples of the types of entities subject to 1557 and the proposed rule once it's finalized: healthcare providers, health-related schools and education and research programs, state agencies such as Medicaid, CHIP, and public health agencies, health insurance issuers, navigators, HHS programs, state marketplaces, and then employers offering employee health benefits programs in certain circumstances. The new proposed rule includes several different protections. Protections against discrimination based on sex. This doesn't really have anything to do with interpreters and translators, but since we're talking about the new proposed rule, I thought I'd bring it up. Covered entities must provide individuals equal access to health programs and activities without discrimination based on sex. Women must be treated equally with men in the health care they receive. Under Section 1557 and in the proposed rule, women are protected from discrimination not only in the health coverage they obtain, but in the health services they seek from providers. The new proposed rule also extends the definition of sex discrimination to include discrimination based on gender identity for the first time in the healthcare context. For example, some insurance policies have historically contained categorical exclusions on coverage of all care related to gender transition, and those categorical exclusions are prohibited under the proposed rule. Individuals must be treated consistent with their gender identity, including in access to facilities. HHS did specifically say that they are seeking comment on whether the rule should include specific exemptions from its sex discrimination requirements. For example, exemptions to account for a women's health clinic or a counseling program limited to male domestic violence victims. Obviously, they cater to a specific type of patient. Okay. Under the new proposed rule for access to individuals with limited English proficiency, it bolsters language assistance for people with limited English proficiency so that individuals are able to communicate more effectively with their healthcare providers to, for example, describe their symptoms and understand the treatment they have been prescribed. The proposed rule provides clear guidance on the requirements of the law with regard to provision of language services such as oral interpreters and written translations. Essentially, what they've done is put the Department of Health and Human Services limited English proficiency policy guidance, which was pretty helpful, is pretty helpful. They've put that into the regulations. So covered entities are required to take reasonable steps to provide meaningful access to each individual with limited English proficiency that they serve or encounter in their health programs and activities. For individuals with disabilities, the rule contains requirements for the provision of auxiliary aids and services, including alternative formats and sign language interpreters, and the accessibility of programs offered through electronic and information technology. Now, with respect to this, HHS is seeking comment on several issues. One, whether certain categories of covered entities should have enhanced obligations to provide language assistance services. And two, whether thresholds should be used to determine the minimum number of languages for which covered entities would be required to provide language assistance services. For protections against discrimination based on disability, A covered entity must make reasonable modifications in policies, practices, and procedures to avoid disability-based discrimination, unless doing so would fundamentally alter the nature of the health program or activity. This is really from Section 504 of the Rehabilitation Act and the Americans with Disabilities Act. So the proposed rule is really harmonizing all of these laws together in one place for healthcare providers. Buildings and facilities where health programs and activities are conducted must be designed, construed, and altered in a way that's readily accessible to and usable by people with disabilities. And then electronic and information technology in health programs and activities must be accessible to individuals with disabilities, unless doing so would create an undue financial or administrative burden or fundamentally alter the nature of the health program or activity. And that language is not really new language. So compliance with Section 1557. Under the new proposed rule, each entity applying for financial assistance must submit an assurance of compliance, and then entities covered by the proposed rule must post a notice of consumer rights providing information about communication assistance. Entities are required to post a notice in English and taglines for the notice in the top 15 languages spoken by individuals with LEPs nationally, and may choose to post the notice in other non-English languages. OCR is helpfully going to provide a sample notice and the translated taglines for use by covered entities, and will translate the notice into those top 15 languages. So those will be available to you. Each covered entity that employs at least 15 people is required to adopt a grievance procedure that incorporates due process standards and provides prompt and equitable resolution of grievances under Section 1557. So for this proposed rule, the comments are due November 9th, so that's coming up. If you want to take a look at it and provide your comments, you just have a few weeks to do so. The final rule will be issued based on the consideration of public comments, and once the final rule comes out, it's going to be effective 60 days after publication, unless we hear otherwise. All right, so importantly, Section 1557 and the new regs, when they're final, they don't invalidate or limit existing anti-discrimination laws. Therefore, entities may be subject to independent civil rights obligations separate from Section 1557. So we're going to go over the old laws as well. So the granddaddy of them all really is the Civil Rights Act of 1967, Title VI, prohibits discrimination in federal programs on the basis of race, color, or national origin. And that applies to entities that have Medicare Part A, Medicaid, grants, loans, or contracts with the federal government. Doesn't apply to Medicare Part B, but if you're a recipient of federal funds, bottom line, don't discriminate. Here's an example of a state law. I'm in Idaho, so it may not be helpful to you if you're not in Idaho, but Idaho Human Rights Act, this is the protections provided to individuals in Idaho. Again, I'm just going to reiterate, check your state laws to see if there's anything different that might provide additional protection. So what happens if you don't comply with Title VI? OCR investigations, it is primarily complaint-driven. OCR may perform compliance reviews, but it's primarily complaint-driven. Human Rights Commission complaints in the individual state in which you're located. Other potential consequences and penalties, loss of federal financial assistance, Department of Justice actions. You could have to enter into settlement agreements where you have to agree to put a bunch of protections and safeguards in place, injunctions, penalties, but not just the feds can go after you. There's also private actions, so private discrimination actions, malpractice, others. What must you do to comply with Title VI? Pursuant to Executive Order 13166, HHS issued guidance in October of 2003 that's still really helpful, and this is what has been incorporated into the proposed rule. Requires recipients of federal financial assistance to take reasonable steps to ensure meaningful access to persons with limited English proficiency. And meaningful access generally means interpreters and translations of key documents. So that HHS guidance, which is the Bible for now, depends on 4 factors whether or not you need to provide interpreters or translators. So you're going to, let's just talk about these 4 factors that you need to review. So the number or proportion of limited English proficiency speakers in the service area. The more people who speak the language, the more likely you're going to need the LEP services. If you live in an area where there is a high concentration of speakers of a particular language, chances are you will need to provide those LEP services. So consider prior experience and service to LEPs. Consider census data, school system data, local government data. You're just going to ask yourself, how many people do we have in our service area that speak a particular language? Second factor, the frequency of contact with limited English proficiency individuals. The more frequent the contact, the more need for LEP services. If you see LEPs daily, you got to do more than those who see LEPs only occasionally. So if you see daily, you may need an alternative on site. If you see them occasionally, you may use commercially available telephonic interpretation services. If you see rarely, you may not need LEP services. So the question is, even if we have a lot of people in the area that speak a specific language, how often do we come into contact with them? The third factor is the nature and importance of a recipient's service. So the more important the service, the greater the need for LEP services. Ask yourself, would denial or delay in providing the services endanger those with limited English proficiency? So if the treatment is critical and urgent, you may need to have immediate LEP services. If the treatment's important but non-urgent, you may not need to have it immediate. And if the treatment is not important, you may not need to have the same degree of LEP services available. The fourth and final factor, and I say it is final, the final factor because it is not the most important factor, and please do not make it the most important factor, the resources available to recipient and costs. The greater the provider's resources, the more LEP services are expected, but it doesn't necessarily mean that the less resources you have, the less LEP services are expected. The greater the cost of LEP services, the less reasonable they may be, but reasonable steps may cease to be reasonable where the costs imposed substantially exceed the benefits. But if you're going to make a determination based on the resources available to you, be really careful and document it very carefully because you don't want to keep a person from having LEP services just because it may be expensive. You can't take it too far. It's going to be difficult. It's going to be a difficult argument to make, so you don't want it to be your only argument to make. So these 4 factors, those are the 4 factors. If you were looking for a black and white rule on this, I'm really sorry that I'm not going to give you one. When it comes to LEPs, there isn't one. So what you do is you take those 4 factors and you put them in a basket and you mix them all up and you try to figure out whether or not you need to provide LEP services. So unfortunately, it's going to be a balancing test, and you're just going to have to use those 4 factors and kind of make a determination based on that. So say you've gone through the factors, you've done all of the mixing up and weighing, and you've decided that you do need to provide limited English proficiency services. So what are your options? One of your options is to allow limited English proficiency patients to provide their own interpreter. I'm going to say be very careful with this. You're going to want to advise the LEP that they may receive LEP services for free. You're going to want to tell them or you're going to want to make sure you never tell them that it's their job to provide the interpreter because it's your obligation. it is considered the cost of doing business. You have to provide the interpreter. Unless they want to bring in their own interpreter, and you can do that, but you need to make sure you let them know that the LEP services are available for free. Consider documenting the LEP's choice if they do want to bring in their own interpreter, and consider using an interpreter service to supplement the patient's interpreter, especially if you have concerns about the LEP's interpreter. For example, if you have a concern about the competency of the interpreter, so say a parent speaks a different language, but their child speaks English and they want to use their 10-year-old as an interpreter. You're probably not going to want to do that because you don't know their capacity, you don't know whether or not they're educated enough to be able to translate complex medical information to the patient. Also, if there's any concerns about confidentiality, the patient may not want to disclose information to their interpreter. And then also consider cultural factors, and if you suspect abuse, you're going to want to use your own interpreter to supplement the patient's interpreter, just to make sure that the patient is actually getting the information that the patient needs. Some other options: hire or train bilingual staff. You could use an interpreter or translator services. There are services available. You can use telephonic or video remote interpreter services. That's called VRI. You can share LEP services with other providers, so purchase a bulk telephonic interpretation services and share that cost among other providers. You can use qualified community volunteers as well, but be very careful that they are actually qualified. And then HHS has on its website I Speak flashcards, which are really helpful to identify what language the individual speaks. So definitely I would make use of those if you encounter a patient with whom speaks a different language, that maybe you can't recognize what that language is. And then you can also create an arrangement to refer limited English proficiency patients to another provider so long as there's not discriminatory intent, but be very careful with that. Translations. So meaningful access includes interpreters and translations, and those translations are for written documents, and they are for written documents that are vital documents. So vital documents are documents that are vital to the services being provided and have important consequences if translation is not accurate and timely. The guidance gives some examples of what these documents are: consent forms, complaint forms, intake forms with health consequences, notice of patient rights, notice of eligibility criteria, and then also notice of free LEP services and how they may obtain those services. Non-vital documents do not have to be translated into writing. Those are general information, patient satisfaction survey, menus, large documents such as the enrollment handbook. None of that is required to be translated. There is a safe harbor if you can show strong evidence of reasonable compliance. So those would include if you have a written translation of vital documents for LEP groups that constitute 5% of the service population or 1,000, whichever is less, and then you do oral translation of other documents, you'll fall into that safe harbor. If fewer than 50 people in the LEP group that reaches 5%, if there are fewer than 50 people in that LEP group that reaches 5%, you can provide written notice of a right to receive an oral translation, and you'll fall into the safe harbor there. The problem is that translations are somewhat expensive. So you can standardize and share translated documents to ensure that translation is appropriate, or you can standardize and share translated documents, but if you're going to do that, ensure that the translation is actually appropriate to your practice. Just always be careful with standardized documents. And then some translated documents can also be found on government websites, which is helpful. But again, you're going to want to ensure that the translation is appropriate to your practice. For certain of the documents, consider oral interpretation, and you can use qualified community volunteers to do that oral interpretation. But again, make sure they are qualified, so be very careful with that. OCR has developed some guidance, a sample implementation plan for this that is pretty helpful. The plan's optional, but it can help with compliance if OCR ever comes to knock on your door. They have some suggested steps that kind of follow the additional LEP guidance and also add just some helpful suggestions. So identify LEPs with whom you have contact, identify available LEP services and how staff may obtain them, establish procedures for handling LEP situations, train staff, provide notice of LEP services to LEPs, and then monitor and update your plan because things might change. Your area may receive an influx of immigrants that speak a different language, so you might need to update your implementation plan. So I'll talk about these briefly. Identify individuals who need assistance, and you can do this by posting notice of available language services in commonly encountered languages. And those I Speak cards that I was talking about on the government's website are really helpful. And then include the language as part of the patient's record as well. Inform your staff of language assistance measures. So let them know the types of language services available, how the patients may obtain language services, how to respond to callers who are speaking a different language, how to respond to written communications, how to respond to in-person contacts, and how to ensure competency of interpreters and translation services. Train your staff, incredibly important. Identify the staff that need to be trained. Train them on policies and procedures for compliance, how to implement, train them how to work effectively with in-person and telephone interpreters, orient new employees who may have contact with language-impaired persons so that they're aware, and document and monitor training. And that's really important, especially if an employee screws up and you're going to want to provide evidence that you did train the employee. They just didn't actually comply with the rules. And then provide notice of language services. Post signs concerning services in common languages. Include services in your outreach materials, such as brochures. Work with community organizations to let them know you have those services. And on your voicemail, use that if you need to interpret someone. You can have them hit a button if they speak a certain language, and they can leave a message in that language while you get a translation. And then finally, modify and update plans. So monitor changes in the 4 factors: common groups in the service area, frequency of contacts, importance of services, availability of resources. Monitor changes in services. If you add different services that may require more LEP services, you're definitely going to want to make those changes. Monitor changes in your documents. If you have new notice of privacy practices issued, you're going to want to make sure those are translated. Monitor staff compliance, and then seek feedback from the community. For critical access hospitals, OCR, their compliance review initiative, which I talked about a little bit earlier, they have additional guidance. And you might just want to look at it to kind of see what the government is looking for. It could give you some additional ideas, but they have components and then effective practices, and it's actually a pretty helpful document. Additional resources for LEP, the HHS guidance, which I provided you, the OCR website, there's an LEP website, there's the website for the I Speak cards, and then the OCR Compliance Review Initiative website that we just looked at. Okay, so let's move on to disability issues. The applicable laws, there are different laws, but the Affordable Care Act, Section 1557 that we already talked about, that also applies to disability issues in the healthcare context. The Rehabilitation Act of 1973, or Section 504, recipients of federal financial assistance with more than 15 employees cannot discriminate on the basis of a disability. And then also the Americans with Disabilities Act of 1990. Title II of the ADA applies to public entities, and Title III applies to places of public accommodation, which includes hospitals and physician offices. So you cannot discriminate against those with disabilities in places of public accommodation. Again, state laws might have some type of discrimination protection, so remember to look at the state in which you are located. It's just an example of Idaho's. What happens if you don't comply? OCR, Department of Justice investigations, Department of Justice lawsuits, injunctive relief, damages to aggrieved persons, civil penalties, first violation up to $55,000, subsequent violations up to $110,000. You could have to enter into draconian settlement agreements. You could also lose federal money. And then, of course, there's also private lawsuits. It's simply better to comply. So what can providers not do? Providers may not discriminate against persons with a disability, and a disability is defined as a physical or mental impairment that substantially limits one or more major life activities, including but not limited to caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, etc. You cannot discriminate against persons with a history or record of such an impairment, and you cannot discriminate against persons who are regarded as having such an impairment. What discrimination includes, but is not limited to, failure to make reasonable modifications in policies, practices, or procedures when such modifications are necessary to afford services to individuals with disabilities, or failure to take such steps as may be necessary to ensure that no individual with a disability is excluded, denied services, or otherwise treated differently than other individuals because of the absence of auxiliary aids and services, unless the entity can demonstrate that the person poses a direct threat to the health or safety of others. That's a fairly high standard to satisfy. Unless the entity can demonstrate that action would fundamentally alter the nature of service being offered. For example, if an individual goes to a specialist for a particular problem that the specialist doesn't necessarily deal with, that's not going to be discrimination if they turn them away and say, I can't provide you these services. And then the other defense is unless the action would result in an undue burden. So let's talk about that a little bit. What is an undue burden? It is a significant difficulty or expense considering the nature and cost of the action, the overall size and financial resources of the entity, and keep in mind the government is looking at the overall size and financial resources of the entity. The government really expects that the cost of not discriminating against people with disabilities should be built into an entity's overhead. It's the cost of doing business. Legitimate safety requirements, impact on an entity's operations, and relationship to and overall size and financial resources of any parent corporation. The fact that cost of providing auxiliary aid or services exceeds reimbursement is not in and of itself an undue burden. It is very difficult to establish an undue burden, so be very, very careful. Providers may not impose a surcharge on persons with a disability to cover the cost of auxiliary aids, policy modifications, etc. A provider may not require an individual with a disability to bring their own interpreter. Providers may not rely on an adult accompanying the individual with a disability to interpret or facilitate communication except in emergencies involving imminent threat to safety and there's no interpreter available, or where the individual with a disability specifically requests that the adult interpret or facilitate communication, and the accompanying adult agrees to provide such assistance, and reliance on the adult for such assistance is appropriate. Beware of using family members, though. Like I said earlier, if you're relying on the minor child, it's not something that you should do. Providers may not, the next bullet point, rely on a minor child to interpret except in an emergency involving imminent threat to safety and there's no interpreter available. What else can't providers do? Providers may not coerce, intimidate, threaten, or interfere with any individual in the exercise or enjoyment of their rights. I think that was the issue in that case we talked about earlier, where that provider was hit up with $400,000 in the lawsuit. You're not going to want to coerce an individual to deny or limit the rights granted by the statute. They're their rights, and do not retaliate against the person because they've decided to exercise their rights or have participated in an investigation or action to enforce their rights. So what must you do? Providers must furnish appropriate auxiliary aids and services where necessary to ensure effective communication. That's really the most important part of this, is to ensure effective communication with persons with disabilities and companions with, who may have disabilities, including a family member or other person with whom the provider should communicate with under the circumstances. No auxiliary aids are required if effective communication exists without them. There was a Supreme Court case where a sign language interpreter was not required when lip reading was actually sufficient. But be careful, because the government is probably going to be pretty sympathetic to the patients in these types of situations. So the type of auxiliary aid or service necessary to ensure effective communication will vary in accordance with the method of communication used by the individual, the nature, length, and complexity of the communication involved, and the context in which the communication is taking place. A provider should consult with individuals with disabilities whenever possible to determine what type of auxiliary aid is needed to ensure effective communication. But keep in mind, the ultimate decision as to what measures to take rests with the provider, provided that the method chosen results in effective communication. So basically what this is saying is the ultimate determination rests with the provider, but the provider better be right. Effective communication is key, though. If you can effectively communicate with the patient, you are probably using the correct method. DOJ has suggested that interpreters may be required when complex information is being conveyed. And those are some of the examples there, and that came from the ADA business brief, communicating with people who are deaf in hospital settings, and I believe that was in the materials that we provided to you as well. If not, let me know and I can get that for you. For the hearing impaired, types of auxiliary aids, qualified interpreters on site or through video remote interpreting services, or VRI. And if you don't know what VRI looks like, that is a picture of it up on the screen. But the VRI has to satisfy certain regulatory standards under the ADA, so you're going to want to look at contracts with your VRI services company to make sure they are agreeing to comply with those regulatory standards. For the hearing impaired, other options: oral interpreters that enable the patient to lip read, note takers, real-time computer-aided transcription services, written materials, exchange of written notes, telephone handset amplifiers, assistive listening devices, telephones that are compatible with hearing aids, open and closed captioning, including real-time captioning, voice, text, and video-based telecommunications systems, other effective means of making information available. That's a typo. Okay, for visually impaired, here are some examples that you can find in the regulations: qualified readers, taped text, audio recordings, brailled materials and displays, screen reader software, magnification software, optical readers, secondary auditory programs, large print materials may be helpful, accessible electronic and information technology, and there are other effective methods of making visually delivered materials available to individuals who are blind or have low vision. You can just do a little bit of research on that to find those additional auxiliary aids. Factors to consider in auxiliary aids: the effectiveness of communication without and then with the proposed auxiliary aid is the most important factor to consider. But you're also going to want to consider the nature and complexity of the communication. So the more complex the communication, You may not want to rely on an oral interpreter to do a lip reading. You may want to actually put that communication in writing for someone who is hearing impaired. The nature or treatment of the treatment or procedure, the size of the practice or facility, you can take that into consideration, but be really careful. Cost of alternatives, additionally, be really careful. If cost is ever the major reason why you're not going to provide an auxiliary aid, you need to be really careful and document additional reasons and the cost. It's not that if the cost significantly outweighs the cost or the reimbursement, that it's not necessarily going to be something that helps you, even if it does significantly outweigh the amount of the reimbursement for the procedure. So just be really careful with that. Number of patients who will require auxiliary aids. If you have a fair amount of hearing impaired patients, you're going to want to consider something that's maybe a more permanent and on-site aid. Patient preferences, always ask the patient what they prefer. You don't necessarily have to go along with it, but ask them what they prefer. And then what's your risk tolerance? Consider that as well. All right, so this doesn't have anything to do with communication issues, but because we get so many questions about service animals, I thought I would talk about this really quickly. Service animals are dogs and miniature horses that are trained to work or perform tasks for people with disabilities. The law used to be a lot broader, and then they sort of just reduced it down to dogs, and then recently, I can't remember how recently, maybe within the last 10 years, they added miniature horses, which always just makes me laugh because I think about a miniature horse walking through a hospital and it just doesn't seem right. But miniature horses apparently are very easy to train to be service animals. Who knew? I had someone asking me a question about it, so I just looked it up, and apparently they can even be housebroken. I was picturing miniature horses wearing diapers, but they don't need them. So I want you to read through this slide with me, and every place I say dogs, I just want you to picture miniature horse to make this a little bit more exciting for you. So generally, you must allow service dogs to accompany a person with a disability in all areas where members of the public are allowed to go. You may limit a dog's access if the dog is out of control and the handler does not take effective action to control it, if the dog's not housebroken, or if the dog poses risk to health or safety. So if the dog's going around and biting people, you can ask the dog to leave, and you're not going to get in trouble for it. But I would definitely document what's going on, because if you get hit up with a discrimination lawsuit because you kicked somebody out with a dog that's biting people in the waiting room, you want to have that documentation right there. You can require the dog to be on a leash unless it would interfere with the service that the dog provides. And then you may not, this is really important, you may not inquire about disability or certification. You can't say, you can only ask whether the dog is required for a disability. You can't ask them what disability they have and why they need the dog. Just ask them whether the dog is required because of a disability, and then you can ask what tasks the dog is trained to perform. You can't ask them, how does the dog help you? You can ask them, what tasks is the dog trained to perform? So again, you've got to allow service dogs to accompany persons with disabilities in all areas where members of the public are allowed to go. You may want to consider allowing them in other places if necessary, but generally they're allowed, and miniature horses too. And if someone has had a miniature horse come into their facility, please send me an email because I really want to hear your story. Additional considerations. So just a few other things to talk about before we wrap this up. Costs. It is expensive. Interpreters may cost between $30 an hour to $400 an hour. But again, like I said, the fact that the cost of the interpreter exceeds reimbursement for services does not constitute an undue burden. It can be one factor in the undue burden analysis, but it is not in and of itself an undue burden. So do not make the patient pay for language or auxiliary aids provided by the provider. They can bring their own in, but let them know that they get these services for free. You may be able to seek reimbursement from the insurer or group health plan if the patient's not required to pay. So definitely look into that. There may be federal or state funds available to cover some costs under Medicare or the Children's Health Insurance Program. Small businesses can receive a tax credit for the cost of the services, but no matter what, do not delay provision of the services while you're fighting over reimbursement for it. Timing. Provide timely service. An undue delay can constitute discrimination or effective denial of service. So you're going to want to get a plan together to know exactly who to call and what services to use. Of course, it's going to depend on the circumstances. Where timeliness is important, you obviously cannot delay. Where timeliness is not as important, it may be able to justify some delay, but not too much of a delay. Where that line is, I'm not sure, but just keep it in mind. You can require advance notice of the need for auxiliary aids, but you can arrange for them in advance. So if a patient calls and makes an appointment and gives you advance notice of the need for auxiliary aid, you're definitely going to want to let them know that you need to make arrangements for that. And you can even put it in your notices that you do require advance notice. Paying for the patient's interpreter, again, sometimes patients will bring an interpreter who then later bills a physician office. You're not required to pay for those services unless you agreed to pay for the services. So make sure you have an offer, make sure you offer and document that you have and offered an effective alternative. Never require the patient to provide their own interpreter, like I said. If they bring their own, let them know that you have your own available and you will pay for it with your own, you will pay for your own that you have available, but you're not going to pay for the interpreter that they bring. Patient no-shows. I haven't seen interpretation on the issue specifically, but I think it's really risky if an interpreters often require a 24-hour notice of cancellation. So if a patient doesn't show up for their appointment, can you charge them for the interpreter? And I think the answer is no. I have argued with some people who believe that it is arguable that you can charge them for it, but I haven't seen interpretation on the issue specifically. I think it's just safer if you charge a no-show fee for all patients across the board. So it's not going to, the no-show fee is not going to be linked to interpreter services, and those interpreter services are probably going to cost a lot more than the no-show fee that you charge to all patients, but at least it'll defray the cost some. But I would not charge patients for interpreters that they don't show up for an appointment. But some people have argued otherwise. Qualification of interpreters. So you want to ensure that the translator is qualified. So you're going to want to look, or the interpreter or translator is qualified. So you're going to want to check their certification, check state laws regarding certification requirements. You want to make sure that the interpreter or translator actually knows medical terms, because those might be difficult to translate. And they may not know language regionalism, so you want to make sure that they are comfortable with those. You want to make sure that they're able to communicate with the education level of the patient as well. And then there may be a conflict by certain circumstances, which we already talked about, such as a family member. Just be very careful if you're going to rely on the patient's family member to translate. And then the ability to interpret does not establish an ability to translate. So oral interpretation might be different than, or is actually much different than written communication. So be careful with that. and just really check and make sure that the interpreter or translator is qualified. HIPAA is still going to apply with the interpreter or translator, so get yourself a business associate agreement. So the DOJ has defined a qualified interpreter as one who is able to interpret effectively, accurately, and impartially, both receptively and expressively, using necessary specialized vocabulary. So keep that definition in mind when you're looking for an interpreter or translator. HIPAA concerns, you probably do not need an authorization to use an interpreter. Because the disclosure is for treatment, payment, or healthcare information, but also because the disclosure is to persons involved in the care of the patient. And then you probably don't need a business associate agreement if, well, you definitely don't need a business associate agreement if the interpreter or translator is a member of your workforce. So if it's an employee or volunteer that's under your control, you don't need a business associate agreement. But if it's an outside interpreter or translator, you are going to want to get that business associate agreement. And then if the patient provides their own interpreter or translator, you don't need one. Otherwise, you probably will need one, like I said. Tips: review implementation plan for LEPs from OCR, the one that we provided to you. I think it's really helpful. Develop a policy for communication with persons with disability. So identify patient companion needs, have a process ready for assessing auxiliary aids, have a process for advising patients and family of available auxiliary aids, just so you have that already and it's not something you're scrambling to deal with. Make arrangements to have auxiliary aids available. Train your staff, consult with patients, find out what they need. Make an informed decision based on the applicable facts, including the patient's preferences, the effectiveness of communication, and what type of burden that would put on you as the provider. If you need additional help, these are the documents that I have found to be incredibly helpful. And I think I provided them all to you except for the ADA regulations concerning public accommodation. You can just pull those up online, and it was kind of a large document, so I didn't provide it. But HHS is committed to providing technical assistance. They've translated forms and vital documents. They have training information and best practices. There are grants and model demonstration funds available for LEP services, so it's not something that you're kind of left out in the wind to deal with on your own. There is help available. Here are some websites. There's lots of guidance on the internet, but be really careful that you're looking at the right websites. I would really just start with the government websites because they're actually fairly decent. And then if you have any questions, you can email me. If you have any experience with mini horses, please also email me because I just want to hear all about it. And there's my phone, and I'm available for questions. So thank you guys so much for hanging out with me today, and we look forward to talking again at our next webinar, which I believe is in just a couple weeks. So thanks so much.